Yeah, I can stand. Oh, I can stand.
Okay, we're in good shape because one person dropped out. Unfortunately, at least one of these three is known for being long-winded, so that's the bad news. And then I got worse bad news than that. Sometime between 10 and 11, our testing of national disaster thing, it's just a test, will go off.
Do we have to get under our chairs?
Forgot to cover? So, you know the stairs, don't take the elevator, and you just stay up there. You know how to get out of here. Okay, with that, our next speaker is a political scientist who's an expert on the presidency, and was one of 4 people that saved my butt on a major volume that we wrote on, which was on the FDR presidency. Actually, there's 2 people up here. Steve Shaw saved my butt even more. That's a long story. Somebody dropped out of the project in the last minute. He had like less than 30 days to write a chapter on it shows. Other people had like 2 years to write it. So this is a special panel. I think I may have bumped off the guy who was supposed to be on this panel because you guys could speak for till 10. Well, not for time for questions and answers. So Rodney Grunes is a political scientist who taught forever at Centenary College in Louisiana, and he's an expert on the Constitution, the presidency, and ungodly other things. And he will be presenting a paper on Ben Gurion and Lincoln on Saturday morning. So that's all you get.
Oh, that's okay. That's plenty.
Okay.
Well, okay. If we're going to have a test, perhaps we should switch at least 9 of us in honor of FDR and his court packing plan. You remember the switch of time, which saved 9, which I'm sure will be mentioned by someone. Sometimes the Supreme Court is a central part of a campaign. Seldom, though, in more recent, since Nixon at any rate, have we seen the Supreme Court become an issue that would concern the body politic. But what do when you are president and Congress is passing things and you are signing them and those folks sitting in the marble palace keep saying no and no and no and no, and you got an economic depression you're trying to solve? Well, FDR had to confront a court, appointed people, a court that divided up, sort of interesting, into 3 groups. But it was the 4 horsemen of conservatism that really was the crawl in FDR's back. And so this, to me, is one of the more exciting things when we take a look at the FDR presidency, is to take a look at what he did and the Supreme Court, which kept saying no. And they didn't even have a Tea Party back then. Today, of course, we have a Congress, about 50 people just saying no, and no, and no. With that, Steve Shaw, first up.
Rodney and I first met, boy, this is going to date both of us, but we look young, don't we? 1993. So it was 93, we met at University of Notre Dame. We were both there for a 6-week seminar on comparative constitutional law. And so we've had that relationship for some time. I want to start by thanking Bill Peterson again for once again putting on one of these conferences. I think the first one of these that I came to early 90s, great justices. Bill still lets me come back. I was born and raised in Shreveport, so it's always good to come back. I think most of my relatives are either dead or won't speak to me anymore. But it's still fun to come back. Old home week, and again, seriously, I thank Bill for putting these conferences on. I don't want to say things that you might get into, but if I do, you can correct them. Think of course, the court packing plan of Franklin Roosevelt. I was flying down here. I live in Boise, Idaho, and I got to the airport yesterday morning at 6 o'clock for a 7 o'clock flight. We get on the flight. It's a small plane. It's full. We're not moving yet. Another few minutes, we're still not moving. People are starting to get a little restless. It's Idaho after all. And flight attendant comes on and she says, plane weighs too much. They've overfueled the plane. And so they start to address that by moving luggage around. Well, that's not going to help that much unless we got some heavy bodies in those things. And then they asked for volunteers to leave the plane. They needed 6 people to leave the plane. And, then they started counting. It almost became like an auction on the plane. Give 500, give you 600. And my wife and 2 daughters, especially my wife, it's like if you ever fly somewhere and have a chance to get bumped and don't, just keep on flying, don't come back home and whatnot. So I became one of the 6 that decided to leave. So I wound up flying from Boise, Idaho to San Francisco to Houston to here. Well, on the flight from San Francisco to Houston, I sat next to this young man. Most of them look young these days. And we got talking, great conversation, and he asked where I was going, and I told him why, and I mentioned the presidency, and he says, I kind of dabble in that stuff, I like to read a lot, blah, blah, blah. And he said, let me ask you this. When I told him I taught poli-sci and con law, he said, kind of a general question, what do you think about the Supreme Court? I said, well, can you be more specific? And what he eventually got at, to make a long story short, was, you have these 5 people who, at least in terms of 5-4 vote at least, these 5 people who can tell the rest of us what to do. And he said, that just don't seem right. He's in Houston, Texas, so English is a challenge for him. And I said, well, Tim, you sound kind of like Senator Hugo Black in the 1930s. When someone like Rodney was referencing, Black is saying, here, all these laws are passing, they keep on getting struck down, and Hugo Black says, how can it be right that 5 people can tell, 140 million people what to do? And of course, Black was in part echoing some of the feelings of the likes of Franklin Roosevelt, to some degree going back to his distant cousin, Teddy Roosevelt, right? And to some degree, back to the presidency of Abraham Lincoln. We all know, Lincoln's response to Dred Scott. And as I think of these 3 presidents, what each did in his own context, in part, I think of, if you're a Lincoln, if you're a TR, if you're an FDR, and the court comes down with a decision that, say, in Lincoln's case, you just know is anathema to fundamental national principles. You just know, beyond a shadow of a doubt, for Abraham Lincoln, that Dred Scott in no way can be made legitimate. In spite of your decade-long call for reverence to the law, you also know that decision can't go unchallenged. If you're Teddy Roosevelt, even beginning in New York State with the cigar tenement case, when he's in New York politics, then when he becomes president, he sees the likes of the Sugar Trust case, E.C. Knight case in 1895, or Lochner, of course, a decade later. Here's Roosevelt, who would almost become so apoplectic. Eventually, he says, "Look, I may not know much law, but I know you can strike the fear of God in judges." And so, we know Teddy Roosevelt eventually, after his presidency, addresses the likes of judicial recall, right? Recall of judicial decisions, recall of judges at the state and the federal level as part of his, popular righteous movement to bring about social justice. I noticed one of the books in the other room, Promise of American Life, and there is, Teddy Roosevelt, who would write to the author, Herbert Crowley, that we can't continue to dance with fetters. We have to remove these fetters from our attempt at social justice. Lincoln got to appoint 5 justices to the Supreme Court. He had a great sense of irony when his first inaugural address, he gets sworn in by Roger Taney, not unlike later with FDR being sworn in by Charles Evans Hughes. And just imagine what's going through each of their heads as they're up there on the national stage, and it's like, what, I've got to give you the oath, and what, I've got to take it from you. Just a national drama, really unlike any we've seen in that, at least, specific context. So, Lincoln gets his 5 justices, Teddy gets his 3, and immediately gets upset with Holmes, and you get the quip about a backbone and banana. And then here's Franklin Roosevelt, right? And of course, you come to office as Franklin Roosevelt. You have to get things done, kind of, come hell or high water. And you serve your first term, and there's no chance to begin to address the 4 horsemen of the apocalypse. There's Butler and Vanderbilt or McReynolds and Sullivan, George Sullivan, Utah judge. And so you're thinking, now wait a minute, you're mentioning Franklin Roosevelt, and you're thinking, my gosh, Harding got how many in 2.5 years? 4. Taft gets 6. Hoover gets 3. These guys got to put people on the court, and I haven't had a chance yet. And I have to believe, I'm not the greatest Franklin Roosevelt scholar around, but give me a month, I'll come up with something. And there's Roosevelt thinking, this just shouldn't happen to me, right? I'm Franklin Roosevelt. U.S. Senator George Norris in the mid-30s said, look, the people can change Congress, but only God can change the court. And I think Franklin Roosevelt was probably thinking, well, God just might need a little help here. Almost like Kennedy's, God's work on earth must truly be our own. Here's Franklin Roosevelt said, I got to give the Almighty a little nudge. And so you think of, obviously, Roosevelt's ill-timed, ill-fated, ill-conceived, however you want to qualify it, court packing plan, because it almost always has at least one or all 3 of those qualifiers. And most of the works, over the decades have said, well, this is Roosevelt being rash, or this was Roosevelt, kind of the epitome, walking personification of hubris. And it was a wrong-headed effort, I think. It was perhaps well intended to some degree, though I'm sure, if you read some about this, that Roosevelt did not mind one bit sticking it to Charles Evans Hughes or the court in general. And yet, I don't think it was, as Jeff Sheesall argues in his book, Supreme Power, it wasn't a rash move on Roosevelt's part. And part of what's interesting about so much that we don't have enough time to get into is that both TR and FDR look back at Lincoln, right? For a number of reasons. And here's, TR, especially TR after presidency, when he's out in Denver and out in Osawatomie and, campaigning in 1910 and 1912. He constantly brings up Lincoln. He says, look, in essence, if you guys are ticked off at me today because I have the audacity to criticize the court, well, look at what Lincoln did. When Teddy Roosevelt says this in 1910, he says, look at what Lincoln did 53 years ago when he heavily criticized Dred Scott. Lincoln was very clear in the Douglas debates, in his first inaugural address, saying, there's just no way Dred Scott can be legitimated. I'm not going to go out and reclaim Dred Scott, the man, or his family, but we will work to get that decision overturned. I know it's the law, Lincoln argued, but I'm not going to look at it as a rule of political action. Because if we allow Dred Scott to stand, then eventually slavery will spread all over the country, and it will be a direct violation, if not an explicit repudiation of all that we stand for. And so you think, obviously, here's Lincoln as a lawyer. Here's one who, for decades, has argued for a reverence for the law, and it being, of course, the political religion of our country, as he argued in the late 1830s. And yet, just because the court comes down with this ruling doesn't mean that I am not going to work to overturn the ruling. The language then wasn't as now, but Lincoln was really getting at this debate about judicial supremacy, right? And he goes back to Jefferson, he goes back to Jackson, as Franklin Roosevelt would do, as Teddy Roosevelt would do. So as I was putting this stuff together, I find myself, I kept on coming back to the political scientist Stephen Skowronek and his work on the American presidency, and some of the typology that he uses with respect to various presidents. He argues we have these recurrent themes, recurrent patterns in American politics, where we take on our, as he puts it, our regime commitments and our regime interests. And he classifies Lincoln as a repudiator, because Skowronek argues that all presidents are, as he puts it, order affirming and order destroying presidents. They each come in and they affirm the existing order, presidential oath, for example, and yet they're also committed to change. So they're saying they're going to take some of the order and destroy it. So here's Lincoln. Obviously, he's not going to be James Buchanan or Franklin Pierce. He's a repudiator. He's trying to establish a new regime. You come down to Teddy Roosevelt, and the label that Skowronek uses with him is orthodox innovator. He's not repudiating McKinley, of course. He is this Republican that they thought they were getting rid of, and lo and behold, Saxon's full of changes everything. And he's this orthodox innovator. He's not just going to McKinley. He's going to go in a new direction by staying to the old commitments, and yet look at his language with respect to the end of law is social welfare. Sounds like Cardozo in nature of the judicial process. Here's Teddy Roosevelt saying, I'm not interested in formulas, I'm interested in facts. He's critical of judges for knowing legalisms but not knowing life. As with going back to the 1880s, this was in 1885 again, the cigar tenement case out of New York, or in 1911, the Ives case dealing with the New York minimum wage. And Teddy Roosevelt is just convinced that those rulings reflect an outdated, ill-conceived, and largely rejected economic and social philosophy. And so Teddy Roosevelt is arguing, why do we have to put up with these decisions? Are there not ways to change them? And like Franklin Roosevelt later, Teddy Roosevelt was convinced the amendment process was just way too cumbersome. And when Franklin Roosevelt was suggested, well, let's change the Constitution, right? We can get a new amendment. Congressional laws can't be overridden unless it's a unanimous vote. Or let's change the makeup of the Supreme Court. Or let's have a number of changes and do it by constitutional amendment. And the FDR famously said, well, give me what? Give me $10 million and I can defeat any amendment that you propose. And of course, again, as a repudiator, Franklin Roosevelt was, like Lincoln had been, and other presidents who were aggressive, if you will, they're always thinking that what? Time's not on their side. So they want to act and act yesterday, as we saw in Roosevelt's addresses and other things. So Roosevelt was convinced that an amendment could be defeated. He was convinced it would take too long. He was convinced that it wouldn't get at the heart of the matter. So of course he and primarily, Homer Cummings hatched the ill-fated court packing plan. And I won't belabor all that because I guess on the one hand I stand up here and I think everybody knows about the court packing plan. It's proposed really in February or March of 1937. It's dead by the time the summer's over for a number of reasons, one of which is, Willis Vandevanter decides to retire, and Roosevelt now gets his first chance, and of course his first choice is Hugo Black, and it's like Roosevelt turning to the Senate and saying, up yours, let's see you reject this guy. And then, the Roosevelt court, I mean, he may put it a little more delicately, but not private. Roosevelt, what? You look at all these decisions, Black Monday in 1935 and other decisions that came down over roughly a 2 to 3 year period. More than a few scholars have argued, and I think there's a lot to be said for this argument, that the one decision that really pushed Roosevelt over the edge was Humphrey's executor. Where it's like, wait a minute, you're telling me I can't remove this guy? You allowed Wilson to do it back in the Myers case roughly a decade ago, and now you're telling me, Franklin Roosevelt, that if I don't like this guy and his policy, I can't remove him? I mean, that's when he really took it personally, right? And the conviction was that these guys are, they're antediluvian, they're Neanderthals, they're in that horse and buggy era, right, of interstate commerce, as he famously put it in 1935. So Roosevelt was convinced he had to do something. And it's that classic struggle of presidential aggression, if you will, as Larry Kramer puts it in his work on popular constitutionalism. It's this effort on the part of the president to lead the public in defining what the Constitution may mean. It's the argument on behalf of, as William Forbath puts it, the allocation of interpretive authority. Right? Who's going to have the interpretive authority to define the Constitution, and should it be only the Supreme Court? We know what Jefferson thought about that, right? We know what Andrew Jackson thought about that with the bank veto. Here comes Abraham Lincoln, and he's thinking Dred Scott. What happens if that becomes a new liberal regime, or a legal regime, excuse me? And then TR and his issues, and Teddy Roosevelt was convinced that an upright judge, which he defined in large measure as one who would do what Teddy would do if he were there, I think. An upright judge is one who should be hailed to the heavens. But a corrupt judge, and he didn't mean that in kind of a Cook County or I'm in Louisiana, right? So I can't say Louisiana is corrupt. He didn't mean that corrupt in some ways that we might think of corruption. He just meant almost mentally corrupt, right? Legally corrupt, just unaware of or either opposed to the times in which he found himself. And Teddy Roosevelt argued that kind of judge or set of judges could do more harm to a democracy than any anarchist throwing a bomb. And I think Teddy Roosevelt really believed that. So it's okay. What can I do to change, the makeup of the state judiciary and even the federal judiciary? He was very cagey about not going after the Supreme Court justices personally, as Lincoln would be cagey before him, and FDR as well. I mean, FDR, of course, had comments privately, but justices had private comments about FDR, right? You think of James McReynolds, one of Woodrow Wilson's nominees. I think Woodrow Wilson regretted that to his dying days, but because Wilson also gives us Brandeis, and you think, what's the president thinking when he gives us the likes of the Brandeis, but also gives us the likes of James McReynolds, right? And McReynolds famously said about FDR, I'm never leaving the Supreme Court as long as that wheelchaired son of a bitch is in the White House. I'm just not leaving as long as he's there. And FDR was equally committed to find a way to help him out of the Marble Palace. But FDR was just convinced the fates were against him, right? And he had to do something. So you have this, as Robert Jackson put it in his work in 1941, you have this struggle against judicial supremacy. We have this tension in our system, right? In which we often think we're solving it by talking about the rule of law versus, the old saying, the rule of men. I think the reality is it's both, right? Because the law is not handed down by gods from Mount Olympus. Justice Stone used to always complain about Blackstone, and Blackstone being the culprit in all of this. It's because, we just announced the law. Read Justice Roberts' decision in U.S. v. Butler. Where Roberts famously says, well, you want to know what the Constitution means? Here's the constitutional language. Over here is the statute in question, and you just put them together and see how they fit. And it's kind of the anti-brainiac approach. There's nothing to it. The reality, as we all know, is a little more to it than that. And in his 1908 annual message, I'm getting closer right now. In his 1908 message, I'll stop with this. In his 1908 message, Teddy Roosevelt said, look, and this is more than a rough paraphrase on my part. In his 1908 message, Teddy Roosevelt says, look, judges are often the key policymakers in our system. When judges decide what contracts mean, when they tell us what rules mean, when they tell us what legislation means and whether it's legal or not. These judges really tell us who we are as a people. So it's important that these judges be well informed. In his speech in Denver on August 29, 1910, as he's covering what's 15,000 mile trek around the continent, FDR says, I want men who are passionate. I want these kind of judges on the bench, but be careful of that person who's just a little too wild in the eye. And I've often thought, did he kind of chuckle inside when he made that statement? Because he was often accused of being a little wild in the eye himself, right? And so here's Teddy. He's bombastic. He's convinced these judges are wrong. And he wants to try to change the system because he thinks these decisions, again, like Lochner, like E.C. Knight, the Sugar Trust case, like the Ives ruling from New York, he thinks they're not just wrong in terms of legal doctrine. Right? He knows they're wrong in terms of trying to do what's right by the country. They won't allow, if these decisions are allowed to stand and grow, they won't allow for a proper structural change. And even more so, FDR thought that way, right? FDR, his famous line, to Francis Perkins, he said, it's very simple, Francis. I just want to create a country where no one's left out. And yet here are the four horsemen, and then sometimes aided, by Justice Roberts or by Chief Justice Hughes. And then here comes the court packing plan, and that's all in part torn asunder by West Coast Hotel. Or by Jones and Laughlin, and you get the switch in time that saved 9, which I think Thomas Reed Powell from Harvard Law School gets coining that phrase. And FDR would go to his grave thinking, okay, I lost that particular battle, but I won the war. I put pressure on the court. They came to their senses, and now they started giving us the correct rulings. And I think not unlike Teddy Roosevelt, Franklin Roosevelt argues if you just bring the right kind of pressure to these kind of people who, after all, are not hermetically sealed in the marble palace, you can bring about some change. Because it may be the case that you have to do those things to bring about necessary change. And whenever I think of this period in American politics, or these presidencies like Lincoln and TR and FDR, I think of the very sage advice from Cardozo in his Nature of the Judicial Process, where he famously wrote, the events of history, the tides of time, don't pass judges by. They affect judges like they do ordinary people. And deep below consciousness, or these other factors that, as Cardozo puts it, make the man, whether he be litigant or judge. And I think that the likes of Teddy Roosevelt, Franklin Roosevelt, they were so committed to change that they knew was necessary to save the American experiment. It's easy to put themselves in the shadow of Lincoln, as Roosevelt did September 17th, 1937, when he gives his address, kind of at the end of the court packing fight before the before the Washington Monument there in D.C. And Roosevelt says what we have to have is a layman's document and not a lawyer's contract. In essence said, I view the Constitution as Lincoln viewed the Constitution, and Lincoln did what he felt he needed to do, and so am I. So both TR and FDR, I think, were heavily influenced by Lincoln in the sense of, hey, here's this precedent. If you're president and you're faced with this decision that is just fundamentally wrong, you have a duty. Maybe not unlike your constitutional duty that you take in the oath, you have a duty to criticize that decision, and you have a duty to seek to overturn it. And in that sense, to turn back to Larry Kramer, it's a form of popular constitutionalism, where the president can say, not unlike Jefferson or Jackson, don't I have a voice here too in saying what the Constitution means? And of course, famously, it's like, I put you on the court, I can take you off, or at least I can try to get you off the court, so I can put my guy. He was eminently successful in that regard. So, apologize if I went too long. I'll stop there.
We have, because of the person.
There's no clock up here. We can. There's no clock shop.
That's true. Well, that is true.
Now, of course, there was a difference between the prerogative theory that FDR embraced and the stewardship theory, if you will, that Teddy Roosevelt. And one thing our Constitution doesn't have is a national emergency section, for example, like the French Constitution has, and that sort of stuff. So Stephen Brown is going to continue this conversation on the Roosevelts and the Supreme Court.
All right, well, I'm grateful to be here as well, and grateful to Bill for allowing me to present again. I had an opportunity, it's hard to believe, 9 years ago, I guess it was, with the Madison conference. Just a great experience, a great opportunity to be in Shreveport again. And I am going to go ahead and we'll repeat a little bit of what Steve just presented, hopefully not too much, but when we're talking about Teddy Roosevelt and talking about FDR and their Supreme Court experiences and appointees, there's going to be a little bit of an overlap. So as he mentioned, Franklin Roosevelt, at least among Supreme Court scholars, is primarily remembered for his plan in 1937 to pass the Supreme Court, which involved 6 new members of the court. That's not a huge deal. It's not controversial in the sense of adjusting the size of the court. The original Supreme Court had 6 members. It was later enlarged by Congress, which was principal, to 7, then to 9, then to 10, and then back to 9 where it stands now. So the plan itself wasn't as outrageous as many people would have thought, but the circumstances, it certainly is as pushback, as you mentioned, against the 4 horsemen and the conservative bloc on the court. It met with sharp resistance, even among members of his own party. Franklin Roosevelt was a master politician. He didn't fail very often. This was, in a sense, on the surface, appeared to be a failure, but because of what happened subsequently, ended up being a great success. It was unnecessary to carry out this plan, though, because in March of 1937, Justice Owen Roberts, who had theretofore voted to uphold, or I should say voted against government regulation of the economy, inexplicably switched sides. From that point on, the West Coast Hotel decision, Steve mentioned, began to consistently uphold New Deal legislation. So what Roosevelt's court packing plan did, in a sense, was revealed his belief that he needed a solid core of supporters on the bench. His governing style across the institutions of government didn't recognize the separation of powers so much as separated branches sharing power. And that power that these branches shared would be molded and shaped in the direction that the president wanted. Court packing wasn't new. John Adams, of course, did it first in attempting to secure a Federalist foothold in the judiciary after his party lost both Congress and the White House. But if the presidencies of Theodore and Franklin Delano Roosevelt are any guide, a few of the right people on the bench can have a far greater impact than multiple appointments. At a May 31st, 1906 dinner honoring newly retired Associate Justice Henry B. Brown, President Teddy Roosevelt proclaimed, quote, "Owing to the particular construction of our government, the man who does his full duty on the court must of necessity be not only a great jurist, but a great constructive statesman." And he uses that phrase, constructive statesman, over and over and over again, mostly in speeches related to the Supreme Court justices, either criticizing them or in honoring them. John Marshall Harlan the first at a dinner, Justice Brown, several others, where he would use this phrase, constructive statesman. That's what I wanted to look at a little bit, was what does that mean? There's a progressive era term, and coined in the late 1800s, and then used during the early 1900s. And it was a term, as I said, that Roosevelt, this constructive statesman, used with particular frequency relative to the Supreme Court. Promoters of the expression referred to it, in the words of one scholar, as, quote, "the most elevated kind of statesmanship, which erected political structures, precedents, laws, institutions, even nations. Great leaders, according to Woodrow Wilson, in the words of Woodrow Wilson, quote, "were not merely powers in society, but were constructive force," unquote. The power and influence of constructive statesmen lay in their ability to understand, as Wilson wrote, the direction of their society and exert themselves in pivotal moments. Such statesmen were certainly be sought for within the executive and legislative branches, but for some progressives, the judicial branch was uniquely positioned to have a constructive impact because of the Constitution. Herbert Crowley, again, his Promise of American Life, which is in the next room, in his 1909 book of The Promise of American Life, which Roosevelt greatly admired, Crowley wrote this: "The Constitution bestowed upon the American lawyer a constructive political function. The construction which successive generations of Supreme Court justices have placed upon the instrument has tended to enlarge its scope and make it a legal garment, which is being better cut to fit the American political and economic organism." In other words, as America evolved, the Constitution, as interpreted by the justices of the Supreme Court, did as well. Thus, constructive statesmen on the court had a responsibility, not merely mimic or mime or parrot the ideas and precedents of the past. They had a responsibility to build anew and to create lasting change. Teddy Roosevelt never had an opportunity to appoint a full bench of constructive statesmen, but at least one of his Supreme Court appointees measured up to that term, if not to Roosevelt's expectations. Justices William Moody and William Day were highly accomplished in their own right before they joined the court, but it was Oliver Wendell Holmes Jr. who assumed the mantle of Roosevelt's constructive statesman, while at the same time deeply disappointing the president. On July 10, 1902, Teddy Roosevelt wrote to his good friend and Massachusetts Senator Henry Cabot Lodge about, in this letter, set forth the arguments for and against elevating Oliver Wendell Holmes Jr. to the Supreme Court. Lodge strongly recommended that he be elevated. Justice Brown, who was Justice Gray, I should say, who was stepping down from the bench, was from Massachusetts. At that time, it was expected the court would always have a Massachusetts seat, and so he's looking at Massachusetts for an appointee. So, in his letter, Roosevelt lays out basically the pros and cons of elevating Oliver Wendell Holmes to the Supreme Court. In his favor, he lists his character, he lists his reputation, his personality, the good name he inherited from his father. To these, he added Holmes' gallant service in the Civil War, his status for 20 years on the Massachusetts Supreme Court, the last 3 as Chief Justice, and especially for his rulings on behalf of labor and the common worker. All that weighed on the one hand. On the other hand, and Roosevelt admitted this is kind of a petty matter, but he said that the statement that Oliver Wendell Holmes Jr. had made a year previously about John Marshall troubled him. All right, on the 100th anniversary of Marshall taking his seat, this is the previous year, Oliver Wendell Holmes Jr. in a speech before the Massachusetts Supreme Court had noted Chief Justice John Marshall's 100th year anniversary, and dutifully noted, quote, if American law were to be represented by a single figure, skeptic and worshiper alike would agree without dispute that the figure could be one alone, and that one is John Marshall. To that point, it's fine, okay? But then Holmes goes on to speculate that Marshall's greatness may have been as much due to the timing of his appointment and to his intellect and to the convictions of his party. For his part, Holmes said, I prefer a man whose thinking be cosmopolitan and detached. He should be able to criticize what he reveres and loves. He admits that those type of men are not often heralded, but to him they were, quote, the originators of transforming thought. They're often half obscure because what the world pays for is judgment, not the original mind, unquote. In his letter to Lodge, Roosevelt contended that Holmes' speech has shown, quote, a total incapacity to grasp what Marshall did, unquote. No member of the Supreme Court should be a partisan or a politician, he agreed. But in an oft-quoted passage, Roosevelt said that, in a higher sense, in the proper sense, a man is not, in my judgment, fitted for the position unless he's a party man, a constructive statesman, constantly keeping in mind his adherence to the principles and policies under which this nation has been built on, and in accordance with which it must go on, and keeping in mind his relations with his fellow statesmen who in other branches of government are striving with him to advance the aims of government. Roosevelt then went on to define for Lodge what he believed a constructive statesman on the court should be. In a handwritten notation at the bottom of this typed letter, referring to his earlier reference to constructive statesman, Roosevelt said, no man is fit to be in the Supreme Court if he is not a constitutional lawyer, in the sense that Marshall was a constitutional statesman believing in great party principles and willing to continue to the Constitution so that the nation can develop on its broadest lines. In short, what Roosevelt wanted was not a justice who would be a constructive statesman in the broadest sense, but someone who, with allies in the executive and legislative branches, would work cooperatively to promote the party platform. Broad national interest would certainly still be served in Roosevelt's view, but those interests would be molded and shaped by the party and institutional cooperation, not individuality and original thought. Roosevelt apparently entertained his misgivings about appointing Holmes for about a month, but finding other candidates unsatisfactory and being unwilling to look beyond Massachusetts for the appointment, he proceeded to nominate Holmes on August 11, 1902, and on December 4th, Holmes was confirmed unanimously by the Senate. Now, Holmes, of course, had no intention of towing any party line, and thus quickly and predictably disappointed the president with his dissent in the 1904 trust-busting case of Northern Securities Company versus United States. By 5-4 margin, the Supreme Court held the merger of 2 of the largest railroads in the country violated the Sherman Antitrust Act. Holmes, however, offered a scathing dissent, which earned him this off-quote denunciation, which Steve mentioned, I could carve out a banana, a judge with more backbone than that. Despite having significantly influenced legal thought prior to joining the court with his treatise The Common Law, his association with the legal realist movement, and despite his important rulings and dissents regarding judicial restraint, liberty of contract, and substantive due process, Holmes never became the type of constructive statesman on the bench that Roosevelt envisioned during his lifetime. Just 3 days after Roosevelt's death, Holmes embarked upon an intellectual and jurisprudential journey that would yield a constructive and enduring transformation of the First Amendment's free speech clause that persists to this day. On January 9, 1919, the Supreme Court heard oral arguments in the first of 3 cases that month involving individuals convicted under the Espionage Act of 1917. In all 3 instances, Holmes upheld the convictions over the First Amendment arguments of the defendants. In doing so, however, he also set forth a standard for the governmental regulation of speech that vastly expanded the protection of the First Amendment. That standard was first enunciated in the first of these 3 cases, Schenck v. United States, which involved the printing of some 15,000 leaflets opposed to the United States involvement in World War I that were subsequently mailed to potential draftees. Holmes wrote, quote, "We admit that in many places and in ordinary times, the defendants, in saying all that was said in the circular, would have been within their constitutional rights. But the character of every act depends on the circumstance in which it is done. The question in every case is whether the words used are used in such circumstances and are of such a nature as to create a clear and present danger that they will bring about the substantive evils that Congress has a right to prevent. It's a question of proximity and degree." With that standard, the clear and present danger standard set forth, what Holmes does is repudiate what had before been the common law understanding of governmental regulation of speech, which was, if speech had a bad tendency, however that's defined, all right, government had the right to regulate it based on the obscene nature of it, or its influence possibly on national security, or if it just had a bad tendency, you could go ahead and regulate it. Holmes said, this isn't that, this is a clear and present danger given that we're at war, but basically on the continuum of speech regulation, whereas here you could regulate speech from this point up, clear and present danger said, basically at this point you can regulate. A very narrow field, primarily national security related, where there's a clear and present danger. A year later, he'd go further. When the court used his clear and present danger test, misapplied it, Holmes thought, in Abrams versus United States, 1919, he, in dissent, argued it's only the present danger of immediate evil or an intent to bring it about that warrants Congress in setting a limit to the expression of opinion. Congress certainly cannot forbid all effort to change the mind of the country. 6 years later, again, in Gitlow versus New York, in dissent, where Benjamin Gitlow had published the left-wing manifesto and distributed that, hoping that it would call for this overthrow of the government that people would act upon. Holmes wrote, "It said that Gitlow's left-wing manifesto was more than a theory, that it was an incitement. Every idea is an incitement. It offers itself for belief, and if it's believed, it's acted on unless some other belief outweighs it or some failure of energy stifles the movement at its spur. If, in the long run, the beliefs expressed in proletarian dictatorship were destined to be accepted by the dominant forces of the community, the only meaning of free speech is that they should be given their chance and have their way." This, again, opens up the marketplace of ideas notion of speech that has been a staple of free speech clause jurisprudence ever since. Now, legal scholars have often faulted Holmes for his inconsistent approach to free speech generally and for his own clear and present danger test specifically. There's no question that his decision in Schenck and his 29 years on the bench completely reframed free speech issues. In refusing to perpetuate common law deference to reasonable legislation, majoritarian definitions of bad tendency, and subsequent regulation of speech, Holmes launched what would become a broad, permanent change to free speech jurisprudence associated with constructive statesmen, a great jurist. One of Holmes' biographers, G. Everett White, has written, "While Roosevelt may have been disappointed with Holmes' judicial performance, it's unlikely that any other president would have nominated Holmes to the court. He had not been the choice of McKinley, he would not have been the choice of Taft. His nomination was made possible by the death of a Republican president and the fact that the first vacancy during Roosevelt's tenure came from Massachusetts." But a different way, a Roosevelt scholar has observed, it's hard to imagine the history of the court in the first 30 years of the 20th century had Holmes never served. Theodore Roosevelt had opened the gate and in a certain sense made Holmes in history possible. I might say that the same could be said of Franklin Roosevelt and Hugo Black. Judicial scholar Henry Abraham has noted that no mystery attends Roosevelt's motivations in selecting his Supreme Court appointees. Those appointees need to support presidential authority, they need to support Democratic Party ideals, but in Abraham's words, what was also critical was absolute loyalty to the principles of the New Deal, particularly to government regulatory authority. As a U.S. Senator from Alabama, and one of only 4 senators in the United States Senate, Black had supported every single one of Roosevelt's 24 New Deal programs. Only 4 senators showed such loyalty. His loyalty, coupled with the fact, as Steve mentioned, that he was a sitting senator, his confirmation by his colleagues was virtually assured, regardless of what they might have thought about his qualifications. And realizing that, they convinced Roosevelt to select Black as his first Supreme Court appointee when Louis Van Banner announced his retirement at the end of 1937. Black was everything that Holmes was not. The last of 8 children, Black was born in impoverished circumstances in rural Clay County, Alabama, never completed high school, and his only judicial experience prior to joining the Supreme Court consisted of a single year as a police court judge in Birmingham. However, Black was intellectually gifted and extraordinarily well-read. He entered Birmingham Medical School at age 17, but left medicine after a year to enroll at the University of Alabama School of Law. While enrolled in law school and painfully aware of his own academic deficiencies, he reportedly also took the entire liberal arts curriculum concurrently. One of his law professors is quoted saying, "I won't say whether Black is the best student in this school or not. I will say he's learned the most. He had the most to learn." Black was subsequently joined, as you know, by 7 other Roosevelt appointees, all of whom were great in their own way, significant in their own way, none of whom could wear the label of constructive statesman the way that Black did. Just 4 months after he's sworn in, Black joins the majority's opinion of Palco versus Connecticut in 1937. In his opinion in that case, Justice Benjamin Cardozo formally incorporated or made applicable against state and local government infringement the protections of the entire First Amendment, the Fifth Amendment's principle of eminent domain, and the Sixth Amendment's right to counsel in capital cases. Incorporation is the notion of nationalizing the Bill of Rights. All right, when the Constitution was first ratified, as you know, there's great concern about this brand new government, this brand new experiment, and where the only reference to the people is in "we the people" in the preamble. Its ratification was promised to the various states so long as a Bill of Rights was appended to that. All right, that subsequently came under James Madison's leadership. You all are aware of that, but it was only applied to the national government. Cruel and unusual punishment, searches and seizures, free speech protections, all those applied against federal government infringement on those rights. State and local governments could go ahead and infringe upon that. Until 1822, Massachusetts required office holders to belong to a state church. You had search and seizure provisions well into the 60s that we know about, and other things relative to the Eighth Amendment, because the Bill of Rights did not apply against state and local government action. All right, the term incorporation refers to applying the Bill of Rights at every level of government, not just national government. As a body, the justices had always been slow to read into the Bill of Rights protections against state and local government actions that were properly regulated by state law. The argument for years has been, if there's a local police officer or state highway patrol person that's infringing upon your civil rights, look to your state constitution, look to your state Bill of Rights. The National Bill of Rights covers national government infringement. And 6 times prior to Palco, beginning with John Marshall's view of the case in Barron versus Baltimore, the court simply said Bill of Rights don't apply against state and local government action, only against national government action. So the Supreme Court was very reluctant to pursue that. However, once Black joined the court, he constantly prodded his colleagues to expand the constitutional coverage of these amendments. A decade after Palco, Black would issue his strongest statement on the issue of incorporation. In the 1947 case of Atkinson versus California, the majority held that the Fifth Amendment's protection against self-incrimination did not apply to a defendant who refused to testify at his own trial. The prosecutor got up and said, listen, if he would get up and testify in his own defense, we might think that maybe he had a chance of not being guilty. But does he stand up? Not one word. I leave the case in your hands as he turns from the jury. His refusal to comment, he thought, violated, and the subsequent prosecutorial comment, the defendant thought violated his Fifth Amendment right to not incriminate himself. The majority in that case, in Adamson, said that wasn't one of Palco's rights that were incorporated. It's not the First Amendment, it's not the Fifth Amendment's Eminent Domain Clause, it's not the Sixth Amendment's right to have counsel in capital cases. Because it's not within that honor roll of protected rights at the state, local, and national level, it doesn't count, and the Fifth Amendment self-incrimination clause does not apply to this instance. In dissent, Black declared, I would follow what I believe was the original purpose of the 14th Amendment, to extend to all of the people of the nation the complete protection of the Bill of Rights, to hold that this court can determine what, if any, provisions of the Bill of Rights will be enforced, and if so, to what degree, is to frustrate the great design of a written Constitution. During his 34 years on the Supreme Court, Black led the Bill of Rights revolution by constantly reminding his colleagues that infringement upon basic rights occurred at every level of the government. During his tenure, he saw the extension of the right to a speedy and public trial, to freedom from unreasonable searches and seizures, bans on cruel and unusual punishment, among other fundamental rights against state and local government action. While total incorporation still has not been adopted by the court, nearly all of the Bill of Rights, word by word and clause by clause, have in fact now been incorporated. Black's long tenure on the bench would have been noteworthy regardless, given his expansive view of the free speech clause. As you know, he viewed that literally, where it says Congress should make no law. He said no law means no law. There's no restrictions on speech so long as it's speech alone, not accompanied by action. his sanction of wartime presidential authority due to the detriment of civil rights of Japanese Americans in the Korematsu versus U.S. case, his erecting of the jurisprudential wall metaphor in Establishment Clause cases by citing Thomas Jefferson's citation of Roger Williams' wall of separation metaphor and incorporating that into church-state litigation were all very important, all controversial contributions of Hugo Black. As a constructive statesman, Black's insistence on a corporation led him beyond the interests of state in these previous positions. As one scholar has observed, he fully met FDR's expectations, of course, but that was in the short run. The New Deal, as such, had spun its course by the end of the 1930s. In the long run, Black's achievements encompassed securing the central meaning of the Constitution and the Bill of Rights. Now, the pinnacle of his legacy stands the now all but complete nationalization of the Bill of Rights. Now, it's possible to argue that the incorporation would have happened at some point anyway, but without Hugo Black, it would have been much longer in coming to the judgment of every American. In his 1901 speech honoring Chief Justice John Marshall, Oliver Wendell Holmes declared, quote, "A great man represents a great ganglion in the nerves of society." Or to vary the figure of speech, a strategic point in his campaign of history, and part of his greatness consisted in his being there, which he emphasized. Holmes was more correct than he knew. As mentioned above, neither the Boston Brahmin nor the backwoods boy from Alabama would likely have been appointed to the Supreme Court under any other circumstances. When presidential interests, circumstances, opportunity, and history collide, Holmes and Black were there. Holmes never did all that Theodore Roosevelt hoped. Black did far more than Franklin Roosevelt wanted. Serving 29 and 34 years on the court respectively gave both Holmes and Black the opportunity and the time to patiently construct and implement their constitutional ideals. As constructive statesmen and great jurists, they're among a very few number of judges who have fundamentally transformed American society. Thank you very much.
Questions?
Professor Brown has cited for us the lengthy history of the changing number of members of the Supreme Court. At the same time, we all know that President Franklin Roosevelt was a master of educating the public through his fireside chats. And I'd like to ask both Dr. Brown and Dr. Shaw for their opinions as to why President Roosevelt failed to present a history lesson to the American people, when clearly many people in influential positions reacted to the court reform plan as a court packing plan, something similar to what was going on in Europe where democracy was dying. Why would the president neglect to use such valuable precedent on such a crucial issue?
Well, Steve can answer here in a second. I think that the reason was he overreached. If he wanted one more, two more, it probably would have. It would have been very consistent with what had happened before. But when you have 6 members of the court that are already at 70, he's got 4 that are already voting for him. He wants 6 more to join the court for each member over the age of 70. Would have been 6 immediate appointments. I think across the country, the public, the newspapers had always supported it. Basically said that looks like a naked power grab. His own colleagues in the Senate, or his party members in the Senate and House, were not aware of it until he made it public. And without conferring to them privately, the better part of them privately, they were forced to confront. Maybe this is a bit of an overreach. I think if he'd done 1 or 2, it clearly would have passed. But 6 was just a bit too much, in my opinion.
You know, Felix Frankfurter, told Roosevelt, you've got to. One of his letters to him, he said, "You've got to go about educating the public." And you think, well, you could have done that. He should have done that. I think so much of it is one. Roosevelt enjoyed doing this secretly and deceptively, and he had talked with his Attorney General Homer Cummings for 2-3 years. Let's see what we can come up with, and Cummings had commissioned people in the Justice Department. Look at this. They were telling him why. And I think in part Roosevelt just really enjoyed the secrecy and the deception involved in it. Plus, two more things at least. One, he seemed to, or did, throughout the whole spring, summer, 37, almost even to the point where the thing collapsed in the Senate, especially in the Senate Judiciary Committee. Roosevelt knew the people were with him. When people would say, when aides would say,
you sure this is working, Franklin? Or are you sure it's wise to take a 2-week vacation now when this is going on? You sure it's okay to do things this way? He said, yeah, the people are with me. The people are with me. And then, in terms of, well, why go for 6 when you can get, say, 1 or 2, because it won't take much to tilt? Well, he had promised Joe Robinson a seat on the court, right? And here's Joe Robinson. He's conservative. He's quite conservative. And he thought, okay, sure, I can put Joe on the bench, but that won't tilt the balance like I want it tilted. And why go, Robert Jackson told him this, and I forget the other aide who did, maybe Benjamin Cohen or Tommy Corcoran. Why go for 2 when you should really pack it and go for 6? Because they said, if you're going to pack it, like, by God, pack it, and really do it. So I think it's almost like a perfect storm, right? That put all this together eventually, where you think, okay, he could have done this, he should have done this. The times were ripe for effecting a change. I mean, there was all this opposition to the court, right? There were all these plans in Congress to change the court and its jurisdiction, and he does it this way, and it winds up looking like he's attacking the court and really even fooling with the Constitution, and now he's gone too far. Plus, finally, even though he had this overwhelming Democratic majority in both the House and the Senate, a lot of those guys, if I may put it in these somewhat crude terms, a lot of those guys are just pissed off at Roosevelt, because he had run things in a pretty heavy-handed way. And so now they get this court-packing plan by messenger in a packet. And it's like they're saying, look, we know you're Franklin Roosevelt, but by God, we're not going to play this time. And so, what Republicans set back, like Bora and others, when the Democrats went after it, and they said, we're tired of Franklin treating us this way, we're not going to do it anymore. And I think especially if he had 1 or 2, say, liberals to put on the court, and not like the likes of a Joe Robinson. And then, when Joe Robinson dies, it's like Roosevelt's accused of killing Robinson. You're pushing this stuff so much that you even drove Joe to have a heart attack. So it's like it all conspired to collapse and implode. Crazy.
Thank you both.
I
would add one other thing to that, and that was the fireside address itself. Instead of dealing with the rulings of the court, that again, as he's mentioned, there's great opposition to what the court had done, what they'd struck down, the mandate that Roosevelt thought he had. He couched that basically in, they're overworked. I want to help them out. I love these guys. They're just, I want to do something to help them out a little bit more, and their docket's heavy, and it's very easily to refute. And Charles W. Hughes ships off things not just to the Senate Judiciary Committee, but also to major newspapers saying, we're good, we're healthy, we're all on top of our docket, there's nothing here. So the way he went about characterizing this wasn't consistent with, he usually nailed how to say things and the right way to present them and frame them, and this one just didn't click.
Do either of you guys think that in the back of his mind was a notion that if he applied pressure, whether it passed or didn't pass, that there might be a change on the current court?
Which is what happened.
Yeah, I think he did. I think he thought in those terms of, the 4 horsemen, that they're beyond salvation. There's nothing that's going to happen with them. I'm hoping that, they die or leave soon. And at one time the word was, it was Van Devanter and Butler. So they were open. Congress had cut the pension. That's like, I can't afford to leave now. I'm staying put. In the cost-cutting measures. And yet Roosevelt thought, well, maybe, with pressure from me and from Congress and the people, that kind of change could occur.
Yeah, I will say too, though, that the 4 horsemen, it was really kind of 3.5, because Roberts was always a little squishy. He'd been more liberal with his rulings, became more conservative, then switched back to liberal with the switch time to save night, and then back to conservative before he left the bench. So you didn't know where he was going. So it's possible he may have had him in mind.
I think that's why Roosevelt still thought, well, I need multiple justices, because while Roberts is with us this season, he's changed several times. What's the guarantee he won't change again next year? So to obviate that possibility, I need 4, 5, 6 justices, because these guys, they're just so unpredictable. And then the Social Security Act and those pieces of legislation hadn't even come up yet, and they were thinking, even with that change, one change in Roberts' vote, this all could be screwed.
Yeah, because I mean, we talk about the people, but really, the people know very little about what the Supreme Court does in a specific sense. They know maybe in a general sense.
And Frank Gannett, with the Gannett Corporation, I mean, he really led the charge to bring newspapers all across the country to defeat this. I mean, this was seen as, an attack on the Constitution and an attack on the court. And so his efforts spent, millions of dollars just sending out editorials and pieces in newspapers all across the country. And it was like, well, what is this? Beginning kind of a fascism coming here with this kind of stuff. So, and then the way they handled it in the U.S. Senate, they let all the opponents kind of go first. Cummings went up there and testified, and was a disaster. Really, the most honest one was Robert Jackson, right? And Jackson goes up there and says, look, this is not so much about old age, this is about ideology. We need some new blood there mentally, not necessarily in chronological terms.
Yes.
If I could go back to Lincoln for a moment. Nobody mentioned suspension of habeas corpus, which is, I think, a very interesting thing. And a few years ago, Sandra Day O'Connor spoke at Gettysburg at the Lincoln Forum. And she talked about, I expected it to be an all-American speech, very light and airy. No, she wanted to talk about suspension of habeas corpus. And how do you think she came out on that? Did anybody read her paper?
I didn't know.
She came out totally in favor of what Lincoln did,
Sure.
which really shocked me. I spoke to a guy in Connecticut who was head of the very liberal group, and he's an attorney and well known in our area. And I said, I told him about the talk. He says, I didn't know Sandra Day O'Connor could spell habeas corpus. Anyway, I thought it was interesting.
Well, you think of what she wrote in the Hamdi ruling about the Constitution not being a blank check
Right.
for the president with civil liberties and fighting a war, and you think of when you look at how scholars are still quite divided and or divisive, perhaps, with respect to Lincoln and how he behaved as a wartime president. And
Right.
I think on the one hand, all right, doctrine of necessity, I'm fighting this war, I'm committed to the Union more than I am to the Constitution, must all the laws but one,
Right.
of course, all that
Right.
kind of language. I think what's interesting about these three presidents that we've been discussing, all three of them were lawyers, more or less. I mean, both FDR goes to Columbia, but doesn't graduate. He later passes the bar, and he says to the Columbia Law School dean, see, I really didn't need your education. TR goes to Columbia for a year or so and quits, but later gets an honorary law degree from Columbia. And then you look at Lincoln, who read the law. So you have these three
And
presidents.
a great lawyer.
And a great lawyer, very successful lawyer, especially railroad lawyer and beyond there, in the 8th Circuit. And you figure, again, here are chief executives as lawyers, and you could think in more recent years, say a Barack Obama or a Bill Clinton, you figure as lawyers looking at the Constitution, and I have prerogative, or if it's stewardship, the public interest, protecting the public interest, I have to do what needs to be done, and it's that classic, how did Alexander Bickel put it years ago, this Lincolnian tension between principle and expediency, and you hope you land on the right one. But you don't know for sure, right? Because Teddy Roosevelt was once asked about how do you make these decisions, and he said, well, I get to a point and I jump, and then I hope I land properly.
And Justice O'Connor also has given other speeches in which she has not quite declared the war on terror as being a quote war.
Right.
Yes, John.
This last comment, hoping you find something I'd like both to think about. You both touched on this in your talks about get back to Theodore Roosevelt and then what you just said about the jumping comment. It's always struck me about Roosevelt that he, for his whole career, he tried to hide the fact that he was an intellectual, although he'd written for years the definitive naval history of the War of 1812. And I think most people today would be surprised to know that he was an intellectual, that he was quite well read and was a prolific author. But he always wanted to downplay that. In fact, his opinion of Woodrow Wilson, once Wilson's ideology conflicted, although they were friends, conflicted, Roosevelt began to attack Wilson not on his ideas, but on his masculinity. And it seems to me the two appointments that you guys discussed that he made, I always thought he sort of made them because they were both high testosterone, assertive dudes. You know, but Roosevelt should have known. I mean, these are guys who are appointed because of their intellectual acumen. They're specific. That's the job that they're there to do. And so we can second guess them and we can question their ideas, but there's a specific reason why jurisprudence scholars were put on the Supreme Court. And it's like Roosevelt that didn't mean a whole lot, and he should have known that.
Think of the kinds of people who go to the court these days compared to them. I mean, you know, Roosevelt really valued, as he put it, you know, the man in the arena, right? And there was that sense of, I mean, he's coming of age when there's the era of what, masculine Christianity, right? And virility and all that kind of stuff. And here's Holmes, you know, thrice wounded Civil War veteran who still had his bloody uniform hanging in the closet. But he wanted to make sure Holmes was the right man. And then with FDR and Black, putting aside kind of the deviousness of, well, let's see him reject Hugo kind of stuff. Here was Black who had been in politics. I mean, of course, FDR wanted that political type on the court. I think, especially FDR, maybe more so than Teddy Roosevelt, FDR really didn't think about their legal acumen that much. Or I couldn't care less if Hugo Black is from Alabama and, you know, Frankfurter's from Harvard or Douglas is from Yale. I want to know if they support the New Deal and if they support kind of restructuring American government because that's what we have to do. And you look at today, you know, what? They're all federal judges. Because of the confirmation mess, we've kind of gotten beyond maybe putting anybody on the court who might have been involved in politics in a way that might result in controversial positions or controversial issues because they won't get confirmed. And something of me thinks we've lost something.
Yeah, I think you're right about that.
You know, I don't know.
Any questions? Well, let's thank our panelists again.